Corporation and Renova Holding Limited.
Please, my Lord.
Now, Mr. Marshall, before you begin, our time is limited, and it might be helpful to you if I were to say two things. First of all, the board would like to hear you on the point on which you've been granted permission to appeal. And secondly, on that point, we've obviously read the parties' submissions. Provisionally, we're inclined to find your submissions the more attractive ones. You may want to, with that in mind, leave more time for your reply rather than focusing principally on your opening. That's entirely a matter for you, but I thought it might be helpful to give you that information.
That's great. My Lord, I'll just briefly introduce everyone. Mr. Weeks is with me for the appellant, Mr. McGrath, Queen's Counsel, along with Miss Arabella Diorio and Mr. Belding, up here on behalf of the respondent. My Lord, as you will be aware, the appeal raises a question of what amounts to an injunction for the purposes of the appeal provisions of Section 30, subsection 4 of the Eastern Caribbean Supreme Court Virgin Islands Act, and in particular whether the asset disclosure provisions of a freezing order fall within the category of an injunction for the purposes of those provisions. We respectfully submit that in that provision, the term injunction has its ordinary meaning in legal usage, which we would respectfully submit has at least the following four attributes. The first is that it is an order that either prohibits a person from doing something or requires a person to do something, which is the expression or form of wording used in the English Civil Procedure Rules glossary, and was also adopted by the British Virgin Islands Court of Appeal in the case of A and E, which your Lordship has, I think, in the authorities at MS page 1859. The second feature is that the injunction is a protective order designed, in the case of permanent injunctions, for the protection of substantive rights, and in the context of interlocutory injunctions for the purposes of preserving the position pending a trial, often in order to ensure that the trial is not rendered, in practical terms, a useless or nugatory exercise. And that is a feature which distinguishes injunctions in our submission from what could be described as process orders. I use that term, and it's derived from an article, or a work, in fact, by Professor Zuckerman on civil procedure. And he categorizes process orders as ones which are really designed to regulate the litigation process, and which in many cases are elective in nature, in the sense that you have a timescale, for example, for the service of pleadings, witness statements, etc. If you do not comply with those types of order, don't serve witness statements or don't serve your pleadings, then that is your choice, but the consequence of it may be that you lose your case, or your case is struck out or dismissed, or something of that nature. In contrast, the protective orders of which we submit we are concerned are not elective in that manner. They have to be complied with. And another feature of injunctions is that they are always capable of enforcement by way of committal and are compulsory in that sense. And then generally, they will be enforced in that way. So there's a third feature. A fourth feature is that they are generally granted on the application of equitable principles and take account of discretionary factors such as delay and other similar factors which are commonly taken into account when granting equitable relief. My Lord, in the case of interlocutory injunctions, there are two further features. The first is that such injunctions are temporal. They last normally no longer than to a certain date, which is prior to that of trial, and may be granted until the point of judgment. And secondly, that they are on a statutory basis, both in the British Virgin Islands and in England. In the British Virgin Islands, it's Section 24 of the Virgin Islands Supreme Court Act. In England, it is Section 37 of the Senior Courts Act, 1981. We respectfully submit that it's because of the impact that an injunction may have and the way in which it affects the respondent's freedom of action that underlies the reasoning for an appeal in connection with those orders being permissible without leave. An order in the form of an injunction compels a course of action or conduct on pain of committal, which is rather different from other forms of interlocutory order. And if I may just refer your Lordship to one passage at this stage in that regard, which is in the British Virgin Islands Court of Appeal decision of Danone Asia, which I think your Lordship has in the authorities. It's in the Primary Authorities, Volume 1, at tab 13, page 1821.
Now we've reached for Authorities Volume 1. Can I just ask you about where we find the British Virgin Islands Act? I thought it was, by reference to the index, 17. But 17, at least in my copy, is the ordinance. So what's the position about that, Mr. Michael?
I must admit, I'd actually proceeded on the footing that that was the act we were concerned with, but
Is it?
let me just check. Both sides have been proceeding on that basis as well.
I'm quite sure that the relevant provisions are the same.
The same.
Nevertheless, one wants to work from the Act.
Absolutely.
Where is it?
Good question, my Lord. I'm sorry to say I'd actually rather
Has it
proceed
not
on the
been
basis of the
spotted?
same.
Has this not been spotted?
I'm sorry to say it hasn't been, but I'm sure the provisions are the same because neither side has taken a
Well,
position
that's
of being
not
different.
good enough.
So, I entirely understand, my Lord.
Very well. Yes.
I'll ask Mr. Weeks, perhaps if you could just check that we've got the actual act. I'll ensure that we actually do have it. My Lord, I'm so sorry. I was just about to take you to tab 13, the Danone case, and I just needed to show you one particular passage, which is on page 1835, paragraph 31. And it's just a passage in which the court, having concluded that a variation of an injunction is within the compass of the provisions that permit an appeal without leave, paragraph 31, the court then referred to the rationale behind the exception, and it adopted the way it was formulated in a skeleton argument that had been put before the court, and your Lordship will see the quotation at the top of page 1836, and perhaps if I could just invite you to read that. It begins each of the exceptions to the general rule. It's because it restricts the freedom of the respondent that one sees the exception being created, and we would respectfully submit that as a correct assessment of why the exception exists. Now, having regard to those features, we respectfully submit that the provisions for asset disclosure within a freezing order have all of the features of an interlocutory injunction and are well within the provisions permitting appeal without leave. Firstly, it's plainly an order requiring the respondent to do something. Secondly, it is protective in the sense that it is designed to operate in conjunction with the freezing provisions in that order to ensure that assets are available for the execution of any judgment, and indeed in international cases where assets are located abroad, as indeed in this case, it has been described, the asset disclosure provisions have been described as indeed the most important element of the order in terms of achieving a protective effect. Thirdly, such orders are granted on the basis of established equitable principles in the same way as a freezing order itself. For example, delay is a factor, and there will be the usual requirements in terms of cross-undertakings and damages, and other forms of cross-undertaking as to use, which will be normally required. Fourthly, such orders are enforced by way of committal. And fifthly, they are granted pursuant to Section 24 of the British Virgin Islands Act, and in the case of England, it would be Section 37 of our Senior Courts Act. Now, in our case, we respectfully submit that the Court of Appeal arrived at a conclusion which was incorrect. Firstly, it did so on the footing that there was no authority indicating that an asset disclosure order could be classified as an injunction. We respectfully submit that was a misconception. There are in fact several authorities which have so classified those orders, including a Court of Appeal decision in England, the case of McLean-Watson, one of the Tin Council litigation cases, and there was a very closely analogous decision in the British Virgin Islands itself concerning a Norwich Pharmacal order in the case of A and E. And A and E was a carefully considered decision which considered two earlier decisions of the Court of Appeal in the British Virgin Islands, and having reviewed the authorities more fully, concluded that those earlier decisions were per incuriam and incorrect. And we respectfully submit that was an important authority for the court to have taken into account. The second matter is that the court proceeded on the basis that an asset disclosure order was really no different from other ordinary procedural orders in the context of an ordinary piece of litigation, such as orders for the service of witness statements, for ordinary disclosure for the purpose of trial, and so on. And drew an analogy with those orders in trying to categorize an asset disclosure order as not an injunction. We respectfully submit in doing that, the court failed to take account of the rather distinctive features of an asset disclosure order, in particular its protective objective, the fact that it was enforced by way of committal, and that it was granted under Section 24 of the Supreme Court Act in the British Virgin Islands rather than any other rule or procedure which would be the appropriate way to proceed if one was dealing with a different type of process order. My Lord, we respectfully submit those observations on the way in which the Court of Appeal addressed the matter and the errors which emerged are supported from by the work of Professor Zuckerman, and his article or work we would respectfully commend to you. The extract, I think, from his book on Principles and Practice of Civil Procedure is in the 5th volume of the Authorities at tab 87.
Which MS page, please?
And I was going to take your lordships to page 3160. And Professor Zuckerman begins by identifying at paragraph 10.6 of his work basic features of interim injunctive relief, which he says are based on three fundamental principles. And the first observation he makes in the first subparagraph is that interim injunctions are available only for protecting recognizable rights, in respect of which the applicant usually seeks some substantive relief, and there's no room for an interim injunction where there's no likelihood of harm to some legal or equitable right belonging to the applicant and enforceable by a final judgment. And he refers in the footnotes to the well-known Siskina decision, namely that you have to have some form of cause of action to base your application for an interim injunction. He then also refers to a second principle, the principle of provisionality. It's not to decide finally the issues in dispute, but to protect rights from irreparable harm pending litigation, and then he makes certain observations about that. And then the third observation is that the third principle holds that if the court finds in final judgment that a party restrained by an interim injunction had been prevented from exercising his rights, the court may seek to restore that party to the position they would have been in had they not been subject to a restraint. And he refers to a principle of restorative compensation. And then he makes the important observation in 10.7 that compliance with interim injunctions, as with other binding court orders, is enforceable by proceedings for contempt of court. And given the serious consequences of breach of an injunction, it's imperative, in the words of Sir Thomas Bingham, that it should be to the highest degree clear and precise, so as to leave the person to whom the order is directed in no doubt as to what is required to ensure compliance. And he goes on the following page, on page 3161, to refer to what he refers to as the dilemma of interim relief, in the course of which he identifies the statutory basis for interim injunctions. And it describes an interim injunction as an order made for the duration of the litigation or part of it, at the request of a litigant, whether claimant or defendant, in order to protect the party's rights until the court can finally adjudicate the dispute. Although an interim injunction may affect the rights in dispute between the parties, it's not intended to provide a final solution to the issues, and the court may grant a variety of interim injunctive remedies, of which the interim injunction is the most prominent, most flexible and far-reaching measure that the courts have at their disposal. Powers as wide as in their reach as they're extensive in their consequences, and without a hearing on the merits and at times even the absence of a person affected, the court may restrain almost any conduct or order almost any action to be carried out, regardless of whether such an order would be available at final judgment. And then the observation, the jurisdiction to grant interim injunctive relief originated in equity, but is now statutory, and then he refers to section 37. And if I may go on from there to move to page 3166, where he makes certain observations on contempt proceedings and how they may be inappropriate as proceedings one's dealing with other forms of procedural order and procedural default. He makes the observation on page 3166 in paragraph 11.213 that committal for contempt is an inappropriate measure for enforcing most process requirements. A court may not commit a claimant for failing to serve the claim form, or a defendant from failing to serve a defence within the time limit for doing so, nor may a party be visited with contempt proceedings for failing to fulfil most other process requirements, such as failing to provide a statement of truth, or failing to file witness statements or expert reports. The great majority of process requirements are electable, and as explained earlier, a party may choose not to comply and accept the consequences of default. And he then refers to parties having some autonomy in relation to procedure. And just moving down a little bit further to paragraph 11.215, he then refers to a judgment in the case of Prudential Assurance and Fountain Page, and quotes from a passage from the judgment of Lord Justice Hobhouse, and which is to some extent instructive. It is said that many things and actions are done because a party is ordered or otherwise required to do them. They're required to deliver pleadings, swear and lodge affidavit evidence, call witnesses, or in the present context serve advance copies of the evidence upon which they propose to rely at the trial. In all these situations, the practical sanction is similar to that which arises from a failure to give discovery or respond to other orders. The primary sanction that the court imposes is to strike out the claim or the defence. If a party fails to deliver a pleading or to lodge or reduce evidence, he will fail to protect his rights and the other party's claims or defences will prevail. The outcome for the litigant is in practical terms the same. However, in legal terms, this is not correct. There is a distinction between orders, the breach of which is a contempt of court, and those orders or rules which merely give rise to a default. The principle of compulsion applies to the former category only. And in our respectful submission, that is a distinguishing feature between injunctions and other forms of procedural order.
Mr. Marshall, you can attach a penal notice to an ordinary order for discovery in an ordinary trial, can't you?
You could, but it would be most unlikely that the court would entertain proceedings for committal for the mere breach, or at least the first-time breach, of an order to provide disclosure. Normally, the court would only entertain committal proceedings as a last resort.
Oh, no doubt.
And it would be most unusual for the court to entertain or allow to proceed an application for committal for a breach of a disclosure order, even a specific disclosure order. The more normal course would be for the court to make an unless order, that unless the order was complied with, then that party's case would be struck out or they would be debarred from defending or something of that nature. And, my Lord, that's a point made by the learned author at the next page, page 3167, paragraph 11.217. This principle is reflected in court decisions. Wherever there is a reasonable alternative available instead of committal to prison, that alternative must be taken, Lord Denning observed. And I think he's referring there to a case called Danchevsky. The appropriate and proportionate response in such cases is to apply the consequences specified by the rules or by court orders for failure to comply. In extreme circumstances, the court may even strike out a party's statement of case, but it would be an abuse of power to commit the defaulting party to prison for contempt of court or impose a fine, unless orders stipulate procedural consequences for default precisely because the court cannot fall back on committal for contempt. And then he goes on to then comment on those process duties which are compellable by contempt.
Mr. Marshall, I don't want to sort of take you out of your sentence, but I'm not sure quite where this is taking us in terms of the issue we have to decide. We want to decide whether everyone's got to go to prison or not. We're trying to decide whether leave to appeal should be given. I don't think you're suggesting that when one's considering that simple question, one has to start thinking about, is this the sort of order I'd commit someone to contempt? And there must be a clearer and simpler test than that.
I think our submission simply is that if one's looking at distinguishing features between injunctions and interlocutory injunctions, which fall within the category of case where you can proceed without needing to obtain permission to appeal first, those sorts of orders are always capable of being the subject of contempt proceedings in order to enforce compliance. Other forms of general procedural order, which order people to do other things, normally will not be the subject of contempt proceedings for the purposes of enforcement. They will be the subject of other types of order, such as the orders described by Professor Zuckerman in the passage I've just drawn your Lordship's attention to. Whereas, in the case of an injunction, always you've got contempt as a possibility in terms of a way of enforcement, which is then the point made in the next passage, paragraph 11.218.
That would be helpful to you if it was a clean division, but it's not, because of penal notices.
You can have a penal notice put on another form of order, But the penal notice is something for the party to put on the order. It's not the responsibility normally of the court to put that notice on. It's left to the party to put it on themselves if they wish to try and take contempt proceedings.
Well, no, I mean, in my line and that of Lady Black, we often in the family division put penal notices on orders for disclosure by husbands because the court wants to know what he's got. So I really don't think there is any clear dividing line between this sort of situation and ordinary disclosure orders.
Well, perhaps the dividing line is simply this, that it's usually the position that disclosure orders, which are not designed to be protective, pre-trial, certainly in the interlocutory context, it's unusual, if I may put it like that, for them to be enforced by way of committal as opposed to by way of unless order or something of that nature.
Okay.
I'll put it no higher than that.
Okay.
My Lord, I just draw attention, just to finish this particular point, and I'll do so quickly, paragraph 11.218 on page 3167, Your Lordship will see the author's observations about the method of enforcement, the regular method of enforcement in connection with injunctions and freezing orders in particular. Now, my Lord, we respectfully submit that the asset disclosure order with which we are concerned with in our case fits within all of the features that normally one would attribute to an injunction. It certainly fits within the wide range of forms of order that the court can make in the form of an injunction. And asset disclosure orders have been described as mandatory injunctions in many instances. Your Lordship will find, we would respectfully submit a helpful observation regarding that in the case of McLean-Watson, which is in the first volume of Authorities at tab 10. And this is a case in which a disclosure order in relation to assets was made independently of any actual freezing order, and there was a question over the power of the court to make such an order. The relevant passage to which we refer begins on page 302 of the report, page 1680 of the record. And this is at just above letter G, where reference is made to an argument that there were divergences of opinion about the permissible limits of the court's discretionary powers to grant injunctions. And having referred to a number of authorities that the appellant's counsel had sought to rely upon, going over the page to page 1681 of the record, just below letter B, the judgment then says, for that purpose, there is no need to look further than the statutory powers conferred by Section 37 of the Act of 1981 and are necessary to consider whether there is any relevant additional inherent jurisdiction, even if it be necessary, to categorize the situation in which injunctions may be granted pursuant to Section 37. There are at least two established grounds which satisfy the relevant tests in the present case. And the first point that they disposed of was the suggestion that the order that was made in this case, which was for the disclosure of assets by the International Tin Council, to enable the plaintiffs to then proceed to execute their judgment in that case, or secure their judgment, was a basis on Susquehanna grounds that there was a judgment already in place and it was seeking to enforce that judgment. But then just below letter D, the court then says this: the ITC's failure to do is a failure to comply with an order of the court and a breach of the obligations owed to the plaintiffs. As Lord Justice Rave Gibson pointed out in the course of argument, it matters little whether one speaks of an invasion of a plaintiff's right or a breach of an obligation owed to a plaintiff. The court's statutory power to grant an injunction, if it appears just and convenient to do so, in this case in mandatory form, is not excluded by any authority. So there one sees the categorization of the asset disclosure order in that case as a mandatory form of disclosure order, which is an injunction. The court then referred to the Beckel and Bilton Authority, which had classified that form of order as being one which is made pursuant to the court's statutory jurisdiction to grant interlocutory injunctions, namely Section 37 of the then Supreme Court Act, now Senior Courts Act. And there was then a quotation from the judgment of Mr. Justice Millett at first instance, who had himself referred to the Beckel and Bilton Authority and certain other authorities. If I go to page 1682, towards the end of the quotation from his judgment, this is at just above letter D on that page. The observation was made by Mr. Justice Millett that it is, however, fallacious to reason from the fact that an order for discovery can be made as ancillary to a Moravian injunction to the conclusion that it cannot be made except as ancillary to such an injunction. The source of the jurisdiction is the same, and so is the ground for exercising it, viz. That it appears to the court to be just and convenient to do so. It is necessary to consider why no such order has been made in the past and why it is sought now. And then he went through the particular features of this particular case, which had led to the court having to exercise powers beyond those contained within the rules to obtain information regarding assets. So your Lordship sees how the matter was addressed, both at first instance and in the Court of Appeal. And the Court of Appeal approved of the way in which Mr. Justice Millett had addressed the matter in the court below.
The point there is that Mr. Justice Millett is saying that your power to make a disclosure order derives from the same section and by implication is itself an injunction.
Quite so.
I mean, is it essential for, in your case here, to say that the actual order was itself an injunction, or is it enough that it's ancillary or an essential ancillary to a freezing order, which is an injunction?
Well, we would respectfully submit that the asset disclosure on its own is an injunction.
I know you're saying that, but do you need to go that far?
Perhaps we don't. Perhaps one could look at the order for disclosure as being part and parcel of one order which contains the freezing order, and one looks at it as a whole, because the two things work in conjunction with each other. And one notices from my learned friend's submissions that they contend that the asset disclosure order is not an injunction within the statutory provision, because it only indirectly, as opposed to directly, protects the claimant's position when they are seeking such a relief. We respectfully submit that's a misconceived way to look at it, because the freezing order and the asset disclosure order are all part and parcel of one package, and they are designed to work together to ensure that the claimant's position is fully and properly protected. And one without the other doesn't normally work very well in practical terms, because a freezing order which is made without any information about where the assets are located is often an order which is not really worth the paper it's written on, because you need to know where the assets are to notify the person who holds the relevant asset of the existence of the order, so that the asset is not moved. So in the classic case, if it's a bank account, you would notify the bank of the order so that the bank would not allow the defendant then to move the asset around or move the money from the account in breach of the order. And if the asset was located in a foreign jurisdiction, one would normally want to obtain information about that asset so as to obtain relief locally in that foreign jurisdiction so as to ensure that that asset was not moved. This is, in our submission, quite a standard procedure which is adopted. But you do need to have the information to make the freezing provisions effective, and that information is only obtainable through the asset disclosure provisions. So they are essential provisions which work together to make the freezing order as a whole effective. But we would respectfully submit that the asset disclosure provisions themselves are an injunction, and they were properly so classified in the McLean-Watson decision in the Court of Appeal that I've just taken your Lordship to. And, my Lord, just to make good my the observations about the importance of the asset disclosure provision, and indeed how it works in conjunction with the freezing provisions of the freezing order to make it effective, and how important the asset disclosure aspect is, I just wondered if I could remind you of the observations in the case of Grupo Torres and Al Saba, which is tab 8 of the authorities. And it's actually a passage from an article by Mr. Lawrence Collins, as he then was, which is quoted by Lord Justice Steyn. And the passage is at page 1638 in the bundle. And if I could just take it up at letter C, where your Lordship will see that Lord Justice Steyn referred to a seminal article, Mr. Lawrence Collins, The Territorial Reach of Morava Injunctions. And in that passage, it stated that in those cases where an effective order can be made, it is likely to be the disclosure order, which will be the most useful in practical terms. If proper disclosure is made of assets abroad, the plaintiff will be in a position to make an application in the relevant foreign court for an attachment. If the foreign court is in a 1968 convention contracting state, it is likely the courts of that state will exercise an Article 24 jurisdiction to make provisional orders in aid or proceedings in England. If the state is not a contracting state, then the same will result in those countries which would allow an attachment to be made in aid of proceedings pending in other jurisdictions. It may be that the number of such countries will be very small, and in most countries it will be necessary to start fresh parallel proceedings on the substance and obtain security in those proceedings. The practical consequence is that it is really the Morava injunction which is ancillary to the disclosure order, rather than the traditional relationship in which it was the disclosure order which was ancillary to the Morava injunction. For the disclosure order will be the main remedy in England, and the Morava injunction will, in the words of Lord Justice Nichols in Babinaft, be a holding injunction to give the plaintiff time to apply to the relevant foreign court for appropriate orders of attachment or the like. Then an undertaking in the form required in Derby and Weldon, or a variant of it, will give the English court power to control the plaintiff's exercise of its rights to seek attachments in foreign countries in order to prevent tactical harassment of a defendant and to limit the plaintiff's security. And Lord Justice Steyn, as your Lordship will see from letter H, indicated that he believed that description of the position was the correct one. We would respectfully submit that is actually describing the importance of the disclosure provisions of a freezing order, particularly one where it is a worldwide freezing order, where one anticipates that there are assets located abroad, which is exactly the type of case we are concerned with in our instance. And we respectfully submit the disclosure order often is not really ancillary, it's in fact the principal relief that you are seeking to obtain, with the freezing injunction being in a way ancillary to it, and with a view in due course to seek further orders in other jurisdictions abroad to ensure full protection is put in place. But the orders are both injunctions, the disclosure order and the freezing provisions, and they work together to bring about the protection that the plaintiff requires. And we would submit, looked at in that way, they properly come within the injunction provisions for appeal in the British Virgin Islands. I have already made some submissions about the consequences of failure to comply with an injunction as being normally committal or contempt proceedings. It is interesting to note that in the context of a disclosure order, where there has been a breach of that, it is not normally treated as by any means at the lower end of the range in terms of proceedings for committal. It is normally treated as a very serious breach at the higher end. I just wanted to draw attention in that regard to the authority of Asia Islamic Trade, which is in the first volume of authorities at tab 5. Very short judgment of Mr. Justice Popplewell at page 1504. And at paragraph 1 of the judgment, the learned judge describes that he had found that certain parties were in contempt of court for failures to comply with the disclosure provisions in a freezing order, which had been made by Mr. Justice Flo at an earlier stage, and he had adjourned the matter for sentencing. But if I could then just draw attention to paragraph 7 on page 1505, he had been referred to a number of authorities, which he then sets out, and from those authorities he then distilled various principles. And if I could then just draw attention to one of the subparagraphs, it's subparagraph 3 on page 1506, a breach of a freezing order and of the disclosure provisions which attach to a freezing order is an attack on the administration of justice, which usually merits an immediate sentence of imprisonment of a not insubstantial amount. And in that particular case, the sentence was one of imprisonment for 18 months for a complete failure to comply with the court's order. I simply draw attention to that to show your Lordship that these sorts of orders are ones which carry a high degree of compulsion behind them, and a failure to comply will, as a rule, be punishable by way of committal, which is another factor we would respectfully submit, putting it within the category of order, which one would normally classify as an injunction. In terms of the statutory basis on which such orders are made, I've already drawn your Lordship's attention to the McLean-Watson decision, which refers to such orders being made pursuant to Section 37 of the English Supreme Court Act as it then was. That was itself based upon the Becker and Bilton decision, which established that, and that has remained the position really ever since, including, for example, in the Grupo Torres case, which I took your Lordship to a moment ago. Again, the basis for the disclosure order is said to be Section 37. We respectfully submit the basis for such orders in the British Virgin Islands is no different. The order is made pursuant to Section 24 of the British Virgin Islands Supreme Court Act, and that provision is the nearest equivalent to Section 37 in the English legislation. Now, with that, can I then just go to the judgment in the court below, which your Lordship has in the record at page 117. Well, I'm sorry, it does start slightly earlier, but the analysis, I think, begins. Perhaps just slightly earlier, at the foot of page 116. Line 24. And
Sorry, can I just check which number on the page you're using?
I'm looking at the MS page number 116, my lord. Line 24.
The inner number, I think.
Right.
Yes. In terms of the actual transcript itself, I believe it's page 54, which is in the top right-hand corner, if that helps. And at line 24, it begins with the word analysis. The sole issue in this appeal comes down to this: is a disclosure order contained in a freezing order an injunction, and therefore leave is not required to appeal to the Court of Appeal against a variation of the disclosure order. It's an unusual situation, and regrettably the searchers of counsel did not produce any authorities that assist us in resolving, presumably, this issue. Therefore, must decide the matter from, and I believe it's probably first principles. Just starting there, we would respectfully submit that wasn't actually a correct position to start from, because there was certainly English authority on the topic, and the court was his attention was drawn to the Group of Torres case, which indicated that the basis for the grant of disclosure orders was Section 37 of the English legislation, which was very similar to Section 24 of the British Virgin Islands legislation. But more than that, there was in fact also a British Virgin Islands case, albeit to do with Norwich Pharmacal orders, but in which the court had concluded that a mandatory order for the disclosure of information was an injunction and was something about which no permission to appeal was required. And if I may, could I ask your Lordships just to note where we find that case? I'll just get you the reference to A and E. That's in the Authorities, Volume 1, at tab 14. And it's quite a strong court because it included the Chief Justice Rawlins and the current Chief Justice, Madam Janice Pereira, now the current Chief Justice in the British Virgin Islands. And in that decision, the court reviewed two earlier decisions, one called Morgan and Morgan and another called TSJ Engineering, which had both thought that, or both concluded that Norwich Pharmacal orders were not injunctions within the relevant provisions of the British Virgin Islands Act. But having considered further authority, which had not been cited in those cases, the court concluded that they were incorrect in parem curiam, and instead concluded that such orders were indeed injunctions. And if I could draw your Lordship's attention to page 1859, and the court referred to various legal dictionary definitions of injunction, and also a passage from the treatise of Mr. G on commercial injunctions, in which he referred to the fact that injunctions can be mandatory, prohibitive, or negative. This is on page 1859. the former requires some positive act to be done by the person enjoined, for example, to pull down a building, or to provide information. Similarly, bulletin and leak contains the statement, often in claims based on fraud, the claimant will seek injunctive relief before or at the outset of the action. The relief is likely to take the form of claims to preserve assets pending judgment and enforcement to preserve evidence, or for the provision, for information and evidence required to formulate properly the claim against the prospective defendant.
So, Mr. Marshall, do you associate yourself with the third line of paragraph 9?
I do.
All orders of the court which command or compel an action by whatever case-specific name it may be called would be an injunction.
No, I wouldn't go that far.
You wouldn't?
I wouldn't go that
No,
far.
I see.
I wouldn't go that far.
Very well.
But I would say that's certainly one facet. And if it's what I would call a protective order, as I described it earlier, and as the Zuckerman text describes it, that is one particular facet, along with the fact that the order is made on equitable principles and is compellable by way of committal proceedings, which makes it an injunction.
Well, if that's the premise of the approach in A&E, do you want to bother with it anymore?
I only bother with it because clearly the court considered that a Norwich pharmacal order, which has got effectively a protective intention, is an injunction and therefore was authority for the approach which I'm adopting. And
What about, how far does it go? I think it's
it perhaps goes a little bit.
Because, what about an order for specific performance? Is that an injunction?
I wouldn't actually have to go that far, and I don't go that far.
Assume that one doesn't normally get orders for specific performance probably on interim applications, but assume that is possible. Assume that happened. Would you need leave to appeal under these rules?
If you could do it as an interim form of order, and it's something that you could enforce by way of committal, and it was based on section, in the British Virgin Islands, section 24, in England, section 37, then it would be classified as an injunction. But I don't believe it would be, in fact. It would be classified as an order made under on a different jurisdiction.
What I'm trying to get at is we're here concerned with a very specific subject, was when you need leave to appeal.
Yes.
And one hopes one has a sort of practical approach. And if one goes back to the Atlas case,
yes.
There was undoubtedly an injunction.
Yes.
And they were seeking to vary it to
yes.
enable them to pay some legal expenses.
Yes.
The actual order in question was now regarded an order to pay legal expenses as being an injunction, but it was
yes.
because it related to an injunction
yes.
that the court said, well, we don't need leave to appeal. Now, that's a sort of good, characteristically a pragmatic approach from then Master of the Rolls.
Yes.
I'm not quite sure whether you're adopting that or not.
Well, I am adopting that, but all I'm submitting to your Lordship is that if you need to draw a line between other types of procedural order and what classifies as an injunction, it's not actually that difficult to do it, because you look at the jurisdictional basis for the court's action, and in our case it's section 24, or if it was in England, section 37, which is the interim injunctions provision. So that's a pretty good guide. And then you look at also what the court is actually doing in substance. And in the context of this sort of order, it's not just regulating how the parties are to conduct themselves in the course of the proceedings. It's actually trying to protect the claimant's rights. It's doing so by the application of equitable principles and the grant of injunctive relief. And it's an order which is compellable by way of contempt. These are all features of an injunction, as distinct from other types of procedural orders for delivery of pleadings or delivery of witness statements or something of that nature, which don't normally have those those features associated with them.
But it's common ground between you that this is associated with the freezing injunction. You can see it in, for example, paragraph
yes.
22 of the
yes.
respondent's skeleton
yes.
argument. It's part of the policing. It's parasitic is the word that they use.
Yes.
Do you need to go further than that?
Perhaps not. I've already submitted that they're actually part and parcel of the same order. And you can't really segregate one from the other. They operate together. They're totally tied together. And it's, as I submitted already, misconceived to simply say that one indirectly protects, whereas the other one does so directly. Neither of them really work very effectively to do anything unless they're together. And that's the point made by Lord Collins in the article which is cited in the Rupertoris case. So just to return to the Court of Appeal decision, we first of all respectfully submit, and this is at page 117 of the record, that the court was mistaken in thinking the point had not been addressed in any previous authority before. It had been. It certainly had been in McLean Watson. And then there's really an assertion that disclosure orders are not injunctions, notwithstanding the fact that a failure to comply with the terms of a disclosure order can make the respondent to the order liable to be proceeded against for contempt of court. And then there's a reference to a party who is ordered to make disclosure of a specific document in the course of pre-trial or trial proceedings and fails to so comply, in appropriate circumstances be liable contempt. But however, this does not mean that the disclosure order is an injunction. Well, rather depends. We would respectfully submit a disclosure order of our type, which is made on the basis of Section 24 of the British Virgin Islands Act, which is for protective purposes, which is punishable by way of contempt, and which is granted on equitable principles, clearly is an injunction, and is quite different from other standard procedural type of orders designed for preparation for trial, service of witness statements, pleadings, and even disclosure, which normally don't have those features and would not normally be the subject of proceedings by way of contempt, but rather by way of an unless order or striking out order or something of that nature. So we do respectfully submit that the Court of Appeal erred, both in terms of the preceding authorities and guidance that one derives from them, and in terms of how it compared the asset disclosure order in our case, which was linked to a freezing order, and worked with it as one order, as compared with other sorts of procedural orders that one commonly sees which regulate the standard conduct of litigation. My Lord, that's really, I think, all I wanted to say on the main point on which we have permission to appeal. I'll save my powder for reply on any further points that are raised by Mr. McGrath, unless your Lordship has any particular questions in relation to what I've said so far.
So as I understand it, you're submitting in the first place that the disclosure order is itself an injunction.
I am.
And do I understand that your alternative position is that the disclosure order and the freezing injunction are so inseparably linked that the right of appeal in respect of the injunction must be construed as carrying with it a right to appeal against the other parts of that order?
Yes, and I would respectfully submit they're inextricably linked and they work in conjunction with each other to bring effective relief for the benefit of the relevant party who's applied for it. My Lord, I just mentioned, and only briefly, we raised a couple of other issues in our case, as you'll have seen.
Yes.
One point is this, that we've been somewhat troubled by the fact that the respondent, really throughout the process, has been adopting a position that they have not submitted to the jurisdiction of the British Virgin Islands Court, and indeed not subject to this court's jurisdiction, which we just don't understand at the moment, because the court has determined that this party has been served. They have not served an application to contest jurisdiction, and the time has long expired for them to do so. And so it's just not feasible for a party in that position to come to this court and say to this court, we're not subject to your jurisdiction. If they want to run that argument before another court, then fine, that's their privilege, of course. They can try to say that they were never subject to the British Virgin Islands Court's jurisdiction, but we do submit, it can't be open to them to say to this court that they are not subject to his jurisdiction. And that's the only point we really make in that regard.
Yes, it appears from your submissions that your position is that, looking at the matter objectively, they must be taken to have submitted to the jurisdiction of the BVI courts and indeed this court.
Yes, absolutely. And all the cases that my own friend has referred to in his case about people being able to preserve their rights to contest jurisdiction, notwithstanding their opposition to a freezing order, they're all cases in which that party still had the ability to challenge jurisdiction. They had only just been served with the proceedings, and they were yet to serve their acknowledgement of service, and they were well within time to challenge jurisdiction if they wished to do so. But we're not in that sort of case. We're way past that stage, and the court's already...
But I mean, why does this matter? This is your appeal.
Well, indeed.
You're complaining about the confidentiality club.
Yes. I can only say it's on... My instructions are that we are concerned that this point is being repeatedly taken or suggested before the British Virgin Islands courts at all levels, and all we submit is that it's not a position that they can properly take before this court. If they want to argue that sort of point or take that position, if they want to do so before a foreign court, that'll be for them to do at another stage. But before this court, it's not a stage. I say nothing more than that. That's all that we wish to say about it. And the only other thing I just wanted to say was that obviously underlying all of this is a concern about a confidentiality club that has been imposed, which prevents me from receiving any instructions in relation to the material that's been provided pursuant to the disclosure order. It's a very strange situation because at an earlier stage in the proceedings, the learned judge at first instance, Mr. Justice Walbank, having heard argument on the point, concluded that a confidentiality club was not warranted in connection with an earlier, quite wide-ranging disclosure order which preceded the application for freezing relief. But at a hearing which was within very, very constrained time limits, and without having heard any argument on the point at all, and really having dissuaded me from making any submissions to him on the issue, proceeded to impose a confidentiality club in connection with the information that came from the respondents pursuant to the order.
Did you say you were persuaded not to make submissions about it?
Well, actually, I was told not. He didn't need to hear from me at all.
But that didn't disable you from getting up and saying, Lord, I would be very grateful if you would hear me briefly on this new point.
Well, what actually happened was, having said that, he just moved straight into his judgment.
Mr. Martin, you're such an able, experienced advocate. You could have got to your feet.
I actually didn't know what he was going to say, my lord. It was only after that he then said, imposing a confidentiality club. So if I'd known, I would of course stood up, but he just went in to do it. So that was just unfortunate. And we've got this situation where we've got a hearing at the end of the month where... well,
that's the point. I mean, this you say, well, in June he'd rejected the idea of a confidentiality club, but the context of this disposal was the pending application of Renova for the discharge of the entire ex parte order.
Yes.
So that gives a different colour to it, doesn't it?
Well, there are two aspects to why the confidentiality club causes problems. One is because we can't get instructions from our clients regarding the material that's been provided, which is important for the actual effective enforcement of the freezing order. That's one aspect. The second is that in the light of that disclosure that we've received, we would like to take instructions for the purposes of what we say in answer to the application to discharge. And unfortunately, we're on quite tight time constraints now. We would obviously be delighted if your lordships were prepared to hear the underlying substantive matter. But if you were not, all we would ask is if there's anything that could be done to encourage the Court of Appeal to address the underlying substantive appeal just as soon as possible, and preferably prior to to the hearing of this discharge application, if it could be done. But it's not a very long point, and your Lordship has got submissions in the annexures to the case to cover it if you wish to hear from us. But perhaps I'll have to wait for your Lordship's indication as to how you like us to do it.
Yes, well, we'll take one fence at a time.
So,
yes.
I note on that basis that my friend didn't cut his cloth
Mr. Weeks following.
that much shorter.
Yes. Mr. McGrath, I should have asked Mr. Weeks if he was going to follow. No.
I apologise.
Very well, Mr. McGrath.
Well, of course, the short answer to the very last point that was raised about the difficulties said to be caused by dealing with anything that arises in the discharge application at the end of May is that, as is extremely common these days in commercial cases in which confidentiality clubs are imposed, there is a liberty to apply. So if my friend has indeed identified an aspect of the disclosure that has been provided subject to those restrictions, which gives rise to the need to take instructions from the client, he has a route available to him without causing any the Court of Appeal to have to move itself very quickly, or this court to have to take some sort of leapfrog procedure to deal with it. It's a procedure that's inherent in the order that has been granted.
Well, Mr. McGrath, that's all very well, but we've read the trial judge pouring cold water on that idea, haven't we?
Well, no, my lord. I mean, if there's a ground upon which my friend needs access to his client,
Didn't the judge say, I would be unlikely to alter this?
well, my lord, the order that was provided expressly includes the liberty to apply.
Well, I know it does. Anyway, there it is.
And therefore he has that route, and that's the route that we say he ought to at least investigate before going any further. Now, my Lord Carnworth raised a point about adopting a practical approach to this matter, and if I could begin my submissions by going back to the order which is the subject matter of this appeal, because of course if my friend's appeal is successful, then it is orders of that nature which will be subject to an automatic right to appeal to the Court of Appeal, rather than going through the filter. And it's the order of Mr. Justice Wallbank, and it's to be found in Bundle A, tab 8. And the MS page is 138. And the actual provision is on page 140. And the court will see on page 140 that there are two aspects to the order that is the subject matter of this appeal. The first is paragraph 2, that the time for compliance by Renova Holding with its obligations under paragraph 7.1 to 3, which is the provision of information paragraphs, shall be extended to 4 p.m. on the 7th of June. So the first one is an extension of time order, and the second one is paragraphs 3 and 4 is the club that my friend's just been referring to, and paragraph 5 is the liberty to Emmerson to apply for permission, etc., to share documents with others outside of the club. And those two aspects are the type of orders we say which are case management decisions. Whether or not to extend the time for compliance with disclosure is the stuff of a judge exercising his discretion based upon the material before him. And we say that if one were to grant this appeal, then you will be running against the tide of where the statutory scheme is intending to go. Because the statutory scheme in the BVI, which hasn't gone as far as where we are presently in the UK, but the statutory scheme there is that all interlocutory appeals are subject to the filter of leave, unless you fall within a particular category. And we say that The categories that have been identified there in section 30, subsection 4, are categories that deal with the conduct relating to the handling of a minor, injunctions, etc., which are categories that affect the liberty of the person, directly impinge and impact on the liberty of the person. And they are orders that one can imagine, of their very nature, would justify an automatic right to appeal. Whereas when one moves to the disclosure provisions, providing documents and information, and then one moves a stage further away from that to the time at which one ought to do it, we say we're simply not in that category of the type.
Sorry, I was really, when I was talking about pragmatic, I was referring back to Atlas, which we haven't looked at. But I mean, that's exactly the sort of point which might have been made there. All that was an issue there was whether someone should be allowed to spend some money on legal expenses, which classically would be something for the trial judge. And yet, because it was part and parcel of the injunction, the court said that was enough to bring it within the exception.
My Lord, yes, although, I mean, obviously what we're doing here is we first have to attach the disclosure order or characterise it as an injunction in itself, and then we work that it's a variation of that order and therefore would be a variation of an injunction and therefore fall within the category of an automatic right of appeal. But what I'm saying is that...
Well, unless you categorise the whole thing as attached to the freezing order.
And then we would say the automatic right of appeal applies to the injunction, but it doesn't apply to the ancillary disclosure order. That would be my respectful submission to the court. But sorry, my Lord.
Oh, sorry. Yes. Well, I just wanted to ask why you say that the disclosure order doesn't affect the liberty of the person because of the consequences of non-compliance and committal.
My Lord, clearly, on one level, it falls within the definition of the wide, I say definition, I take that back, the descriptions that have been adopted for injunctions in terms of restricting behaviour or mandating certain behaviour. It clearly falls within those very wide descriptions, and I'll be addressing you why it is that they don't apply here. But one is dealing, in this case, with disclosure of documents. Now, the answer to your Lordship would be, if the consequence of not disclosing it is because it's got a penal notice, it's committal, I'd say, well, does that elevate the order or change the fundamental nature of the order from a disclosure order as commonly understood to an injunction, just because the penal notice, which might be imposed because the court has imposed it for its reasons, as my Lord Wilson indicated earlier, or it might be imposed subsequently by the party, that itself can't possibly alter the nature of the order. The sanction, it would be the tail wagging the dog, that the sanction then determines the characteristic of the order. And if you happen to put a penal notice on, it's an injunction, and if you don't happen to put a penal notice on, it won't. And given the uncertainties and vagaries as to when penal notices might be put on, as my Lord Wilson and I believe also my Lady Black indicated, one then is into a field of uncertainty.
Right, but I thought that you began your submission, section 30, subsection 4, is dealing with categories which affect the liberty of the person.
Yes.
We know that injunctions are included there. The only reason injunctions affect the liberty of the person is because you can be committed if you breach it. And that's why I ask you, well, that's a feature of a disclosure order as well. Why isn't it the same linkage in the case of a disclosure order to the liberty of the person as there is for any other injunction?
Because, my Lord, then where does one stop? Because all procedural orders involve some form of impact on the liberty of the person, the ability to, the requirement to take a step. Whatever the sanction that might be applied is an infringement on or an impact on the ability of an individual to act. And we would certainly urge the court not to open up Pandora's box to allow all such orders to fall within an injunction. So we say, well, that can't be the defining feature to bring an ancillary disclosure order within the definition of an injunction for the purposes of section 30, subsection 4.
Yes, thank you.
Whilst you've paused, can I just see how far you're going? Suppose we look at it from the other side for a moment, from the point of view of the person who is the subject of the injunction. Suppose that it is granted with a disclosure order, but no confidentiality club. And the person subject to the injunction says it should have a confidentiality club associated. Has that person got a right to appeal?
My lady, what would happen in those circumstances is, under BVI law, is that the appeal would be by way of leave to appeal, and that we shouldn't be concerned or worried that that is a filter that would apply, because the import, respectfully, of your ladyship's question is that this is considered to be an important matter as far as the respondent
No,
to
I'm
the
just asking us to see how far you go
Yes,
with it, because you could say that that was a matter as to the terms and conditions on which the injunction was granted within Section 24.
Well, no, my lady, we break it down. The confidentiality club only applies to the disclosure aspect, and when one then looks at the confidentiality club, it doesn't vary the obligations on the respondent to make the disclosure. It actually imposes fresh requirements and restrictions on the recipient of the disclosure, the holder of the order, as to what they are entitled to do. So what, to answer your ladyship's question, and
Well, the simple answer is yes, leave is required.
Leave would be required, but that we ought not to be worried about that, because if it's a sufficiently important matter, then leave would be granted. That is the appropriate filter. And that is precisely how matters would be dealt with here in the United Kingdom, where all such orders would be subject to leave. And it would then be out for the putative appellant to persuade the court that it was a sufficiently serious matter. And in my respectful submission, that filter is consistent with the statutory scheme of reducing the Court of Appeal workload in respect of interlocutory orders. And we would say, I've set out in our statement of case the statutory scheme. Your lordships and ladyship will be very familiar with it. A general rule that there should be no appeal without leave, subject to exceptions. And we say that for my friend to succeed, he should present a case which does not ride coach and horses through those exceptions and that scheme, and that the exceptions listed that give rise to an automatic right of appeal should be narrowly construed, and certainly insofar as the attempt to do otherwise and introduce ancillary disclosure orders causes or introduces additional layers of uncertainty in the process and what might fall within it. And that is something that this court should bear in mind as to whether or not it ought to accept those submissions. And my Lord Wilson indicated earlier, as I believe from family law background, as to the ability to put on penal notices or not, and whether or not that's a defining feature. Some of what my friend, he placed his case very much on the statutory basis, but then sought and prayed aid in the Norwich pharmacal jurisdiction, which doesn't derive from the statutory basis. So one needs to be very careful how the arguments have been put. But there are two points I would make, two hurdles initially when one looks at the statutory scheme that my friend must get over. The first is extremely obvious, and it might be said to be a banal point, but I'm going to make it. There is no express mention of discovery orders or disclosure orders in the context of the list of exceptions. I make that point because the discovery order, as that language was in play at the time, is as well established a feature of equitable relief as the injunction was. And had it been intended to include it, I make the submission that one would have expected it to have been included, rather than what we now have today, an attempt to shoehorn some sort of disclosure orders into a category that naturally does not cover and is not used, the language is not used to describe disclosure orders. My friend has been able to show one or two case examples, but these disclosure orders have been around in various shapes and forms for decades, if not longer. One would have expected the cases and the judgments to be full of the analysis of these as injunctions, but one just doesn't see that. And one of the points I will make in a moment is that when one actually drills down to see what it is, if this is an injunction, what kind of injunction is it, then it has to fall into that very rare breed of an ex parte interim mandatory injunction. Now, the court will be well aware that those sort of orders are considered to be at the rarer end of injunctive relief being granted and strict criteria being met before the court will impose such obligations on. But not a word of the sort of concerns that those type of injunctions give rise to will you find in a discussion of an ancillary disclosure order. It's not treated like that because it isn't one. Now, the second hurdle that I mentioned at the beginning is the public policy hurdle. And my friend took you to the Danone authority. And we say that any appeal here needs to grapple with what is the public policy driving the need for the ancillary disclosure order to be the subject of an automatic right of appeal. We say it can't be and isn't its association with the injunction. But one can understand why the American cyanamide injunction, or as in this case, freezing or Morava injunction, to use the old language, falls into a category where the public policy is such that one ought to have an automatic right of appeal under the BVI legislation.
Why is that?
Well, it's described, well, I'm somewhat trite to say it now, but as one of the common law world's 2 nuclear weapons, because you can, by this order, do all manner of things, such as from freezing the assets of an individual on a worldwide basis without him having an opportunity first to be heard, telling his banks that he's subject to an order that might ruin his creditworthiness and ability to borrow money and do business. All of it, and the orders now, my lords, are becoming more and more sophisticated in the context of the terms of the injunction and what one can do, taking passports away until you provided your disclosure, etc. So,
but surely the seriousness of the consequences of an asset disclosure order militate in favour of a right of appeal, don't they?
Well, my lord, that would then be to elevate every order that has serious consequences into one that has an automatic right of appeal. And in this case, that would have to be to fit within, shoehorn it within one of the listed exceptions. And we say, I mean, in this jurisdiction, when I say this, I mean in the UK, English, Welsh jurisdiction, we don't have an automatic right, and no one considers that to be an infringement of our human rights. Because if the point is sufficiently serious, if the particular disclosure order really is causing manifest harm to a respondent in its present terms, then that is a point that will get you through the filter.
But that's an argument against having automatic rights of appeal. But we know we've got an automatic right of appeal. It's just a question of in this case, a question of the interpretation of it.
My lord, yes, and it's not. But in this case, the issue for the court today is not so much the consequences of the order and whether or not the order should give rise to an automatic right of appeal, because that is an argument, if I could throw back to the court, if I respectfully say, for an extra exception for such orders. But the point and the work for the court today is whether the ADO, the ancillary disclosure order, falls properly within the category of an injunction. So, my Lord, I would say it doesn't fall within the category of an injunction, even if one puts a penal notice on it, and even if the consequences are serious. But we shouldn't fret ourselves about that, because if those consequences are indeed serious in a given case, then they will get through that filter. Now, my Lords, my third point is that the answer to this appeal does not lie in the wide description, and I use that term deliberately, of an injunction. My friend has referred you to various cases that have identified it, and your Lordship, my Lord Wilson, raised the issue about the Court of Appeal in A versus E, and certainly one of the points that we would make is that adoption of such a wide view as a qualifying factor for an injunction would indeed ride a coach and horses through. The scheme being a general right that you need leave, subject to a very limited series of exceptions where you have an automatic right. The language simply doesn't get you there. And my Lords, I don't wish to take up time taking you through matters that I know your Lordships will have, and your Ladyship will have read, but you will have seen in our statement of case, at paragraph 40, our reference to Gumamar and Lehane, where they make the very point. For your Lordship's reference, the MS pages 3003 at 3005 to 3006. But Gumamar and Lehane make the point, well, when one opens up the standard texts, and in no way being disparaging by saying standard text, the leading texts, one is hit with a definition or a description of an injunction which covers all sorts of procedural orders that clearly are not understood commonly to be injunctions. And so the learned authors there, who certainly know their equity, pray in aid to be careful with trying to get too much out of such a very wide definition. My Lords, if I could take you to just two cases dealing also with this point. The first in bundle 1 of the authorities bundle, it's the case of Magnani and Magnani, and it's MS page 1688, and it's hard copy bundle 1, tab 11. Now, this was a case in which, and I'm going to take your Lordships and Ladyship from page 1688, the bottom third, paragraph beginning with the point raised, just so your Lordships and Ladyship can see where this is coming from. The point raised on behalf of the respondent is that an order made under Section 24 of the Matrimonial Causes Act, pursuant to Section 24(1)A, being an order that a party to the marriage shall transfer to the other party such property as may be so specified, etc., etc., is an injunction within the meaning and intent of subsection 18(1)H3 of the Supreme Court Act, which is, marries the same Section 24 of the BVI Act. That novel and startling proposition was presented as follows. When you look at the judge's order, which was in its express terms an order made pursuant to Section 24, it ordered the respondent husband to do something, that is to say, to transfer against his will the property named in the order. The next stage in the argument was this. Mr. Payne's read as part of the opening paragraph of Mr. Fox's article, which says, an injunction is a judicial...
I'm not with you. Which page are you on?
1688. And it's at the very bottom, my Lord.
Okay.
And we were just getting on to the quotation from Mr. Fox's article. An injunction is a judicial remedy by which a person is ordered to refrain from doing or to do a particular act or thing. In the former case, it's called a restrictive injunction, and in the latter, a mandatory injunction. So, based on that description of an injunction, the argument goes to Mr. Payne submits, there you are, the respondent was ordered by Mr. Justice Wood to do something, namely to transfer property at Fulham Road, and the editor of Holsbury describes an injunction as a remedy by which a person who's ordered to do something ought to do something. Therefore, for the purposes of the construction of the relevant statute, Mr. Justice Wood thereby made an injunction. And as he made an injunction, his order was an exception to the restriction in Section 18 upon appeals to this court, and leave was not necessary. And he says, if one moves to the paragraph beginning, Mr. Paynes invites us, at the second sentence he says, I've no hesitation in moving that this is a complete misunderstanding of the meaning and the effect of the exception in 3, relating to the grant or refusal of an injunction. The injunction there contemplated by the draftsman is an equitable remedy, which since 1875 has been a remedy which all divisions of the High Court have power to grant. The origin and history of that equitable remedy is too well known to make it useful for me to lengthen this judgment by elaborating upon it. Suffice it to say that there are all kinds of orders being remedies that the court in different jurisdictions is entitled to grant whereby persons are ordered to do something. One series of such statutory remedies are the orders which derive their efficacy from Section 24 of the Matrimonial Causes Act. This particular one is generally known as a property adjustment order. It's an order sui generis. It has nothing in common with the equitable remedy of an injunction, and it's perfectly plain as soon as one looks at the drafting of the exception, the Parliament is contemplating in 3 the equitable remedy of an injunction and the grant and refusal thereof. If it was necessary, so he says he disagrees with that interpretation. He goes on to say if it's necessary to derive assistance from the other exceptions, one finds a sufficiently clear indication in exception 2. That reads, where an applicant for access to a minor is refused all access to the minor. Orders for access are usually both mandatory and restrictive. And when an order for an access to a minor is made, the person with care and control to the child is ordered to do something, namely to permit the other parent to have access to the child, and that the other parent is subjected to a restriction in that he or she is prohibited from access to that child, save as specified in the order. If the submission of counsel was right, and that the draftsman in exception 3 meant the exception to extend to any order of the court which orders a person to refrain from doing something or orders a person to do something, what Parliament, ordinary orders for access would be within exception 3's injunctions. It's quite plain that that is not what Parliament intended or contemplated, because exception 2 distinguishes orders for access where some access is permitted from orders for access where all access is refused. In that latter case, Parliament has provided that leave to appeal is unnecessary. So that would be a pointer, if it was thought necessary, to look for a pointer to the intention of Parliament. But when the draftsman drafted the 3rd exception, he was not thinking at all about orders made pursuant to the specific statutory remedies in the Matrimonial Causes Act.
Mr. McGrath, is all this a bit of an Aunt Sally in the light of Mr. Marshall's concession that he couldn't associate himself with the wide analysis of an injunction in the A&E case? Could I put to you what, as I understand it, is really the nub of the case against you? And we've all got the transcript of the submissions made by your predecessor in the Court of Appeal, very seductive submissions. And if you've got page 77 to hand, I wonder whether you'd be prepared to go to line 24. Here is your predecessor saying that the asset disclosure order is, quote, absolutely, inextricably linked to the injunction. And that is more or less what you said in your own case. Now, not just linked, but inextricably linked, Mr. McGrath, which means you couldn't separate them even if you wanted to. And I think the case against you is that you are separating them. You're saying that there can be an appeal as of right in relation to the freezing, but not an appeal as of right in respect of the absolutely, inextricably linked disclosure order. What do you say about that?
They are certainly linked, and by virtue of being linked, to have a link, one needs to have two aspects: the injunction and in this particular context, the ancillary disclosure order. Do I accept that it is typical and the norm that an ancillary disclosure order is granted for the purposes of most injunctions? The answer is yes. Do I accept that you can have, that the importance of the disclosure order is of the same level in all cases of an injunction? No, because the example that my friend didn't cite is the example of a freezing injunction in which you do know the assets, and indeed a targeted freezing injunction in which you know the assets are simply money in a bank account or trust assets that are held in a particular location. Where the freezing order is a targeted freezing order of that nature, and you are supposed to identify in the order those assets that you are aware of. Now, if that's the nature of the freezing order, then the disclosure order either is not necessary at all or plays a far more peripheral role in the effectiveness of the injunction. But I accept that if one has a very large claim, as is quite a common feature in the commercial and chancery divisions in England, and one is pursuing that claim and gets a very large freezing order, then the ancillary disclosure order serves an important purpose. And we accept that the language used in case of Motorola of giving teeth and bite to the injunction in terms of identifying the assets that might be subject to the injunction. But if your Lordship listens to, sorry, if your Lordship understands why I put that point, identifies the assets which are subject to the injunction. So the ancillary disclosure order is doing and performing one task, but the injunction is the one that is doing the real task of imposing restrictions on what can be done with those assets. But I accept that in order to police the freezing order, knowledge of the existence of those assets is important. And it may be you already have that knowledge, or it may be that you need to gain that knowledge via the ancillary disclosure order. But what we, my Lord, I will get on.
I took you out of turn.
No, but I will.
You said you wanted to refer to two authorities.
Yes, my Lord.
You've only referred to one.
The other authority is Morgan & Morgan Trust Corporation, which your Lordships will find in Bundle 1 of the authorities at tab 15. Page 1869 of the MS. And all I was going to draw your Lordship's and Ladyship's attention to was paragraph 6 at page 1869, where the judgment reads that the Discovery's respondent's other submission that a disclosure order is an injunction is a completely novel one. Counsel was unfazed by his inability to find any judicial decision or academic writing that supported his view, and easily offered the suggestion that basic propositions were frequently assumed without discussion. It was a fleet response. A knowledge pharmacal disclosure order is a highly specific type of order. It compels the production of information to enable a party to put forward his case. An order for disclosure does not become an injunction because it commands a person to do something. If that was so, all orders that commanded persons to do things would be injunctions. An order for specific performance compels a person to do the thing he'd promised to do, but that does not make it an injunction. Similarly, an order for an account compels a party to do something, but it is not an injunction. The reason why these other orders are not called injunctions is because they are not injunctions. That last sentence may not be particularly helpful in finding a reasoning, but it's helpful in one sense, and it's in this sense that, as I indicated earlier on, you just don't find detailed discussions in the case law of disclosure orders, however one puts them and describes them, as being injunctions. We're having to deal with that now because we're trying to shoehorn an ancillary disclosure order into one such injunction. Now, my friend made reference to the English White Book glossary, which has a similar, very wide definition of an injunction, namely a court order prohibiting a person from doing something or requiring a person to do something. But the point I would make about that, in addition to all the other points, is that glossary doesn't even work for the White Book, because we know that the definition of the injunction gateway, for the purposes of serving out under, put aside Section 25 of the Civil Jurisdictions Act, in the BVI one still has Mercedes-Benz and Leipzig, that one is not allowed to apply, we're told by the Privy Council, a literal interpretation of what amounts to an injunction for the purposes of that gateway. Otherwise, one would be able to use the gateway to serve out a freezing injunction. So, my Lord, there's a danger, I say, in taking the line of a wide definition or description and running some distance with it. An example of that danger, Lord, is the exchange that took place in the court below between my friend and the Court of Appeal when the question was asked of him, well, doesn't that make all disclosure orders injunctions? Or do you say all disclosure orders are injunctions? And your Lordships will see that in Bundle A, tab 7, and it's the MS page of 100. And the question at the top of the page, at the bottom of the page below, the court said, so to take on Mr. Fay's example, yes, a disclosure order for specific exclusion in the normal course of proceedings, is that an injunction? It could be.
What's that mean, specific exclusion?
My understanding of that, my Lord, I mean, and it's only my understanding from reading it, is when it's talking about normal course of proceedings, is a specific disclosure order as one would find in the normal course of proceedings. So you have your normal disclosure, and then one party might ask for a specific disclosure. And he's asking, the court is asking, does that specific disclosure order become an injunction? Or do you say it's an injunction? And Mr. Marshall's response to it was, it could be. It could be framed that way. You could have an order for disclosure which was accompanied by a penal notice, and if it was, and it was framed in mandatory form, it could take the form of an injunction. It's not impossible. It would be fair to say that most, in many cases, people don't ask for an injunction in the form of a simple disclosure application. They don't put a penal notice on an order, and it's not intended to operate in that manner. They only apply for an order of that kind if the first order they obtain is not complied with. But it's possible it could be done. And, my Lord, my lady, we say that, firstly, in that answer, there is an implicit recognition that disclosure orders do not naturally fit within the characterisation of an injunction. Disclosure orders generally, across the board. But that it is possible to turn one into an injunction if one frames it in a certain way and puts a penal notice on the top. And we say that both those points are bad points. The mandatory language will appear in any coercive procedural order and therefore would elevate every single order that required a party to do something or not do something into an injunction, and that can't be right. The penal notice says nothing we say about the fundamental nature of the order as opposed to the potential availability of a particular sanction for breach thereof. An injunction without an endorsement of a penal notice does not cease to be an injunction, any more than a disclosure order with such an endorsement suddenly takes on the mantle of an injunction. the role of the penal notice is not to change the nature of the order. And one knows that, and we can test that, because it can be put on after the court has granted the order, and might even be put on without the court's knowledge. Not in a nefarious way, but because that can be done. And it can't be seriously suggested that by doing so, the recipient of the order has changed its fundamental nature to that of an injunction. Now, following from those two features that Mr. Marshall identified, which we say neither can be defining features to convert a disclosure order into an injunction, and bear in mind the way it was couched, it could be, and bear in mind my submissions that this appeal should not be allowed if it's going to introduce uncertainty into the exceptions, then we say that both points simply don't carry this appeal forward.
Can I just ask, what is the function of a penal notice? I have to confess, I'm not familiar with the practice that my Lord Wilson and my Lady Black mentioned in the family division of attaching a penal notice to something that isn't an injunction.
It's to warn the respondent to the order that there are particular consequences that will flow or may flow from a breach of the order. Now, that could be committal and imprisonment, it could be sequestration or attachment of assets, depending on whether one's talking about an individual or a company. But the overall purpose is to make it clear to the respondent what is available to the court by way of a sanction should there be.
It is a sine qua non of a later application for committal, isn't it, Mr. McGrath?
My Lord, yes, it indicates that you are running the risk, if you breach this order, of being found to...
But you couldn't apply for committal unless the order upon which you're basing yourself carries a notice.
Absolutely, my Lord.
Yes, very well.
The CPR rules make that very clear. There is, I should say...
And that's true in the BVI as well, is it?
My Lord says yes. I should say, of course, there is the possibility of dispensation from notice, but we're talking about exceptional circumstances for that. For example, one exceptional circumstance to place in the context might be that the individual was in court when the order was made and it was explained to him and the consequences. If it didn't have a penal notice put on the top, he's going to have a tall order saying the absence of a penal notice means I don't suffer the risk of contempt.
I understand that in relation to injunctions, but what about in relation to disclosure orders just made in the ordinary course of proceedings? As I understood it, you were saying that a party can just attach a penal notice to that.
My Lord, yes, you can attach a penal notice.
And what's the consequence of that? That the court can commit you for contempt for not complying with a procedural order?
Well, my Lord, yes. But, I mean, the answer will be, firstly, whether it was appropriate to attach the penal notice to the disclosure. So, for example, it may be a situation in which specific disclosure has been asked and hasn't been provided, and in order to crystallise the mind of the recipient of the order that there are serious consequences if you don't comply with this, that a penal notice is put on. But I don't think the court will look favourably on individual litigants going around putting penal notices.
That was going through my mind, that it seems to be putting some sort of weapon in the hands of a litigant to, speaking colloquially, to put the frighteners on other people in litigation, that they may be sent to prison if they don't do what a perfectly routine procedural order tells them to do.
My Lord, and that will probably provide a filter to prevent abuse of putting it on notices, on orders that it should not go on. But of course, you still have the filter of the court's leave.
So I thought that you were saying that a party can just attach it, that there's not a filter, but when they just attach it, well, to Lord, put the frighteners on, to use my expression.
No. If you put the penal notice on an order that it wouldn't ordinarily go on, simply put the frighteners on there, I suspect the court will look very unfavourably on that. But my point was that I could get an injunction from the court, an American Sianamid injunction or freezing order from the court, having, for whatever reason, omitted the penal notice and put it on. Now, in freezing orders, I could put it on after the... In freezing orders, that difficulty is unlikely to arise because of the standard order, which contains it in the front. But if I went for a bespoke freezing order, or a bespoke injunction, I may have omitted to cast my mind to the penal notice. I get the injunction from the court, and then afterwards I decide to put the penal notice on. Then there would be nothing wrong with my doing that.
No, I think I've understood in relation to injunctions that you need fair warning, usually given by a penal notice to the recipient of the injunction, what consequences may be if they disobey the injunction. I think I understand that. What I was trying to understand was what you say happens where you don't have an injunction, you just have an order for specific disclosure, and then a party stamps that with a penal notice. You seem to be saying, well, the court might decide to commit someone to prison for not complying with just a routine non-disclosure order. Disclosure order.
The bottom line, my lord, is this: that it's always open to the court to find a party to render a party in contempt for breach of one of its orders, with or without a penal notice. If the kind of conduct that I'm complaining about would not give rise to that sort of sanction in a typical scenario, and I put a penal notice on it, it doesn't mean that I'm entitled to render you liable to the contempt process. The penal notice usually uses the language, you may be, and in those circumstances, the penal notice simply means that the court can then decide whether the particular circumstances are sufficiently serious to merit going forward to the next stage. So there's no automatic entitlement. What is quite clear that if you didn't have a penal notice on an order, one would face a very difficult uphill task if you were trying to persuade the court to bring contempt proceedings for breach of that order.
So your submission is the court has jurisdiction to commit someone to prison for breach of any of its orders, provided only that it decides that such non-compliance can be characterised as a contempt of court.
My Lord, yes, but subject, of course, to the point I made to my Lord Wilson, that in the absence of a penal notice, the court will obviously want to be persuaded that it's appropriate to do so, and that will all depend on a fact inquiry as to the nature of the conduct that's being complained about. Now, my Lord, so we've just been talking about contempt, and my friend took you to Adrian Zuckerman's work on civil procedure, and your lordships have seen that. Can I just very briefly show one or two further passages and leave the reference to that? It's in AB5, tab 87, and it's page, MS page 3168. Actually, my lords, if we can begin at 3157, which is the beginning of the section, chapter 10. Now, in paragraph 10.1, Professor Zuckerman identifies the range of interim remedies that are available, and he does it by reference to the CPR in the English jurisdiction, but the BVI have very similar provisions as well. And one can see there's a whole range of interim remedies. First one being the interim injunction, then an interim declaration that goes on. And of course, if one were to apply the kind of definition that's been bandied about, one would feel that they all fall within an injunction, but then one would ask, well, why is 1A not covering everybody else? Could I just draw your lordship's and ladyship's attention to G? That in the case law that the court has seen, it was said that the jurisdiction to provide the disclosure ancillary to the freezing order arose either within Section 24 or 37 or inherent jurisdiction of the court, depending on whether one adopts Lord Justice Stevenson and Lord Justice Ackner's alternative arguments. The law's moved on since then, so it's well, we make sure we're up to date. And G is a provision which is mirrored in the BVI in CPR 1711E, and it's the ability to obtain information about the location of relevant property or assets, or to provide information about relevant property or assets which are or may be subject of an application for a freezing injunction.
Do you have the BVI reference?
My Lord, it's not in the bundle, but we did indicate to my friends that we would bring on the court for this help. I don't know whether the court would.
Thank you.
And so this is now available as a heading, and was one of the bases upon which some of the disclosure orders sought in before Mr. Justice Walbank were sought under. And I just draw it to your attention because, of course, it's a separate section of the rules from the freezing injunction section in 2511F. And the equivalent in the BVI is little j. Now,
so, how are you saying that this helps us? So this is
you can order
rules which post-date the statute that we're construing. Is
yes,
that right?
Yes, you've got Section 24 and Section 37. But we now have in this country CPR 25, and they also have the Supreme Court rules CPR 17. And one of the arguments that your Lordship would have come across in Beckle was the jurisdiction to grant this disclosure available under the rules. And at that stage, there wasn't an express heading that allowed one to do that. Now there is an express heading, which is not the injunction heading. And therefore one could obtain, my friend said that in order for it to be an injunction, one needs to obtain the ancillary disclosure order under Section 25, statutory basis. But if one applies for the very same order under the very same terms under CPR 1711E, then one is applying for it under the rules and not under Section 24. So the statutory basis which he holds out to your Lordships as being the crucial link in the argument that it's an injunction would fall away on an application that applies for such an order under the rules.
But if you apply for an interim injunction, sorry, I'm a bit confused here. Wouldn't you be applying under the rules on this argument? So, sorry, I was understanding.
My Lord, yes, you would be applying under the rules. Right. But the freezing order, the statutory, Section 37, doesn't alter the criteria for an interim injunction, a freezing injunction. It doesn't impose any criteria. That's case law. That existed prior to 37 or Section 24. It doesn't alter, it doesn't turn the freezing order into a statutory remedy alone.
But surely the jurisprudential basis for both a grant of an interim injunction and an order directing party to provide information about the location of relevant property is Section 24, even though these rules exist. These are procedural rules. They don't confer the jurisdiction in the first place.
Well, Well, my Lord says that, but that would to presuppose that there's a statutory basis for all of these rules, which underpins them. And my submission is that...
Must be, mustn't there, somewhere? I mean, that's
well,
not very controversial.
Well,
but it doesn't help. I mean, one sees that a freezing order here is not described as an injunction, but I think you would accept that a freezing order is a form of injunction.
My Lord, yes. I mean,
so it doesn't really help us at all.
Freezing order, changing
What we know is that you can give all sorts of ancillary orders under the general power to award injunctions, because that's what Beckall says.
My Lord, yes. I mean,
E seems to be somewhat narrower than we're concerned with also, because it's focused specifically on relevant property, which is defined in paragraph 2 as meaning property which is the subject of a claim, or in relation to which any question may arise on a claim.
Civil procedure rules quite often channel how jurisdiction, which is granted elsewhere, not in the rules themselves, how that jurisdiction should be exercised. And quite often, civil procedure rules, for the purposes of exposition, list out a whole range of things where the fundamental jurisdiction to grant those other things exists outside the rules themselves. And that's what seems to be happening, so far as I can see, in 17.1. And I gave, by way of an example, B, an interim injunction.
My Lord, yes. I mean, my point was simply that the argument that you can only get these ancillary disclosures under the statute isn't right when one uses the CPR rules to obtain them. And your Lordship will be aware of the argument of Lord Justice Stevenson in Beckall, which Lord Justice Ackner accepted as the alternative to his main argument, that the ability to grant such relief was part of the inherent jurisdiction of the court as opposed to the statutory jurisdiction of the court. So there, but my Lord, looking at the time, on the Zuckerman extract, if I could just draw your attention to pages 3167 and 3168, because a clear dividing line was sought to be drawn between process duties and protective orders, and the use of contempt for one but not the other. But the learned professor goes on, I won't read it out, but the learned professor goes on in this extract to identify those process duties which are compellable by contempt. And in 11.222, the last section, last paragraph on this, 3168, he talks in terms of false statements of truth that one needs to put at the bottom of pleadings and witness statements, and a false disclosure statement. And contempt procedure.
Notice the second sentence of 11.218. An example of such duty is provided by a freezing order that places an obligation on the defendant to refrain from dissipating assets and to disclose their value and location. I mean, there's only so much we can derive from the way in which these things are described, but for what it's worth, the author is lumping disclosure into the freezing order.
My Lord, let me address that. The language freezing order that my Lord Conworth raised with me, we accept that is the appropriate language now, rather than injunction, because it was supposed to be language. But the freezing order is simply the term for the standard form order, which contains the injunction, provision of information, and all manner of other orders, such as service out if that was necessary, provision for expenses, other carve-outs for business operations, etc. So when one talks about the freezing order as a freezing order, it contains that full panoply of remedies. But for the purposes of today, I say that one needs to look within the freezing order at what is the injunction. And we're told what the injunction is. The standard form order tells us
But can we look at 797, which is the order in play?
So
this order, seventh line down, this is a freezing injunction. And then we've got, under that rubric, freezing injunction and provision of information. Again, it only takes one so far, but isn't the order lumping provision of information into the freezing injunction?
it's all contained in one order, yes. And care has been taken to construct that order so that it's well understood by a recipient. But as part of that care, your Lordship will have seen that, our issue today and our aim today is to decide what's an injunction. And one sees very clearly in plain language under this order. We have this, the freezing injunction, and then we have provision of information afterwards. Now, I'm not making a great point on this, save that is how it is done. But I will emphasise, and I have mentioned it, because if the suggestion is going to be that the freezing order is some overall one big beast and everything within it, any issue that arises about it and in respect of it should be given an automatic right of appeal. And I would say that that is not the correct approach, and that the correct approach is to look at what is the injunction, because that is the list of exceptions, a stated list of exceptions, and that is set out there in 4 to 6 and other provisions that relate to the injunction, and that the provision of information is ancillary to that injunction. Important? Yes, but ancillary, distinct and separate from.
Thank you.
Otherwise, why not say the disclosure injunction? If we're going to use plain language and not confuse the recipient, and we think he's confused with the use of freezing injunction as the overall language, because it contains more than an injunction, so we change it to a freezing order, which then doesn't limit it to just being an injunction, that has other matters. Then when one looks at it, we see what's an injunction. That's the injunction. Provision of information. Why not simply say injunction to provide information, or disclosure information, or information injunction? It'd be consistent. Why draw a distinction? Why introduce that inherent uncertainty as to how one might look at the two provisions?
Can we pick up another provision from it then? 10.3, which is one of the you may spend it on this sort of provisions. Is that part of the injunction or not?
Well, my lady, it is part, because it defines the nature and scope of the obligations which are set out, and it clearly only applies on its face to the restrictions under the freezing injunction. But I accept that it comes under the heading exception to this order, but when one reads it more closely, and it wouldn't be the first time one criticises the standard form order for lack of clarity, but when one reads it more closely, it is an exception to the injunction side.
The only reason really I picked that one up was because you'd said that the order included other things other than the injunction, and one of the examples that you gave earlier on, I think, if I'm not mistaken, was being allowed to spend so much.
My lady's right. I would say that we would call them carve-outs or exceptions to the injunction, but they determine and define the parameters of the injunction.
But I do wonder whether another point comes out of my lady's reference to 10.3, which is, to what extent is it sensible to try and pass an order like this, which is obviously intended to work as a comprehensive whole with interlocking parts, each of which supports the other or qualifies the other, in order to say, well, for this bit you do need leave, but for that bit you don't. Why shouldn't one look at the order as a whole and its predominant characteristic, which is plainly as a freezing order?
Will be precisely for the reason that when one looks at the order that we're concerned with today, it has nothing to do with the scope of the prohibitory restrictions imposed by the freezing part of the It's an extension of time to provide documents, and it tells somebody how those documents are to be handled when received. I go back, my lords, to my starting position. That when one is dealing with orders of that type, it is appropriate that one has a filter. The scheme works and will work, does work perfectly well with such a filter. And that if one has, these orders give rise to all manner of issues and contentions. And if every one of them would give rise to an automatic right of appeal, one can imagine the appellate court below will be extremely clogged up with what is quite a very popular order in the BVI. But my point is that an automatic right of appeal should be limited to what is clearly and obviously the injunction, the restriction, and the ability to use those assets. And matters such as disclosure, etc., are matters that, if sufficiently important in any given case, can be the subject of the filter for leave. Now, my lords, dealing with the common statutory source of the order, your lordships will be well familiar with the authorities that we've cited in our statements of case. I'm not going to trouble you given the time, but you will see that the authorities draw a clear distinction between granting the injunction under the primary statutory basis and providing ancillary orders to make that injunction effective. That is the distinction that is drawn. And the majority in Beckor accepted that that was a distinction drawn within the section 24 or 37, so that the power to grant the injunction came with an inherent power to make sure that that injunction was effective. Now, the question I raise in answer to the argument that because it's a common source, both must be an injunction, is why on earth do we talk about or get ourselves in knots as to whether or not the power to grant the ancillary disclosure order arises, as the majority in Beckor said, or as Lord Justice Stevenson said. If they're both injunctions, then they both arise under the primary ability to grant an injunction under Section 37, Section 24. But it's quite clear that the distinction is drawn in the authorities, and one must ask why. And that is because the purpose of the orders is to do two different things. The injunction is there, the interlocutory injunction is there to protect and preserve the rights pending the determination of whatever it is the underlying proceedings, whereas the ancillary disclosure order is there to make good the injunction. And that is a different purpose. And it was said, well, you know, and I know it said, I was prepared to accept that it can be said that if you make good the injunction, then the injunction then can protect the rights, that by granting one you're indirectly asserting, protecting the rights and preserving the rights down the line. But that's the wrong way to look at it. If that was the case, we wouldn't have the discussion about inherent power. We would see it both as protecting the rights, but it's quite clear it doesn't. One is rendering effective that which, being the injunction, protects the rights. The heavy lifting on the question of protecting the rights is performed in all cases only by the injunction. That's the role of the injunction, and that is a defining feature of an injunction. The ancillary disclosure...
But I mean, often the heavy lifting is done by serving the injunction on a bank or a third party. And you can only do that heavy lifting when you know that there is a bank account with that bank.
Precisely, my lord. And so it makes good my point with respect that the ancillary disclosure order is undoubtedly central to rendering the freezing order, the freezing injunction, effective. But the bank's response is dictated by the fact it's been served with an injunction, not the fact that we know via an ancillary disclosure that it holds some assets.
Right. Well, I was really intending to pick up on your use of the word heavy lifting. I mean, I'm not sure it's a very good metaphor, but if one is looking at heavy lifting, and it's really a way of putting to Mr. Marshall's point based on the Lawrence Collins article, that often, perhaps the most important thing that one of these orders does is provide identification of where assets are so that steps can be taken to get them in.
Well, Lord, and I certainly wouldn't, it's not for me to query with somebody of the stature of Mr. Collins, and I wouldn't on that point, that often the disclosure order is extremely important, perhaps more important, but its importance doesn't convert it to an injunction. It certainly can't. That's not a logical argument. No reasoning involved in that. It just says that there may be an argument for I think I made this point to my Lord Wilson earlier on. There may be an argument for including it as an extra exception, but it isn't an injunction, however important a role it might serve in any given case. So, my Lords, we question as well, when one looks at the authorities, and particularly they were the Norwich Pharmacal authorities, where one has the odd references to injunction in play. It really, unless my friend says I'm out of time, but I think he didn't sit down until 25. So 1 hour 15 minutes.
Yes,
I think I noticed
that's what I've recorded as well.
So I know about my 5 minutes now. The Norwich Pharmacal orders that are referred to, there's no detailed discussion of the leave gateway. What one gets is the odd reference to an injunction, and one can understand in a judgment why a judge might refer to such orders as an injunction without intending it to have the consequences that it falls within certain gateways. But of course, Norwich Pharmacal doesn't help my friend, because his case is based upon section 24 or 37, and Norwich Pharmacal is not an order that arises from the statutory remedy. It is an old bill of discovery from equity, and it stands alone, and its criteria for its invocation is entirely separate. It serves no ancillary role at all. It's not there to make injunctions effective. And if it does so per chance. But its justification and raison d'etre is all about being able to exercise one's rights in bringing a claim or knowing who the tortfeasor is. So we say that, and when one looks at the cases that are relied upon where references to injunctions have been said, as your Lordship will have seen in our statement of case, and I won't take time now to deal with it, in the vast majority of those cases, leave to appeal was required. So it was not considered in that case, when people put their minds to it, that its subject matter was the matter of an automatic right of appeal. In circumstances where English law at the time did require, did have the distinction of an injunction exception to the ability to pursue an appeal as of right. I've addressed...
Well, that point doesn't go very far, Mr. McGrath, because, as we all know, so many courts say sensibly, oh, well, I don't know whether you need leave to appeal, but we grant leave to appeal in case you need it. And the curiosity of this case is that that wasn't done in the British Virgin Islands.
My Lord, yes, although I think the only case, there is one case, Lord Donaldson, in the cases before you, took a different line to Mr. Justice Hoffman. Mr. Justice Hoffman had said that leave to appeal was required, and Lord Donaldson indicated in his view for that Norwich Pharmacal it wasn't. But my 2 points were just that the Norwich Pharmacal as a jurisdiction doesn't help my friend. And secondly, even if we're in the Norwich Pharmacal jurisdiction, those cases are cases where leave was required. My Lord, just very briefly, as regards you've seen from our statement of case, as regards the BVI authorities, So one has two Court of Appeal cases and A&E. What I would urge and invite the court to do is that the understanding of A&E about Equatorial Guinea is simply wrong. The discussion and use of the word injunction in that case was clearly relevant only to the substantive claim that was being brought in England and was nothing to do with the Norwich Pharmacal that had been applied for in Guernsey. So to the extent that the BVI Court of Appeal and A&E thought otherwise, it was wrong to do so. We do accept that Lord Justice Templeman used the language of mandatory injunction in British Steel and Grenada at the opening, but A&E wrongly assumed he was giving the leading judgment in the House of Lords on that case. He wasn't. He was in the Court of Appeal. None of his brethren in the Court of Appeal supported that characterisation. No reasoning was presented for it, and the House of Lords judges did not indicate any agreement with that characterisation. The matter was simply a reference en passant, but in any event, it was in respect of a Norwich Pharmacal order. So we say that when one is ultimately looking as to which are the authorities that are more persuasive in the BVI on this point, we say the Morgan & Morgan Trust case that I've taken you to, and the other authority that we refer to in our statement of case, being TSJ Engineering Consulting, is the important one.
Mr McGrath, I'm afraid you are about to trespass on Mr Marshall's time.
My Lord, I believe I've covered what I wanted to cover.
I'm grateful. And Mr Iorio, anything to add?
No, thank you, but no.
Thank you. Mr Marshall.
Firstly, my Lord, in connection with the question that my Lord Wilson raised early on concerning the ordinance and its status, there is a West Indies Associated States Supreme Court Amendment Act of 1993 that was brought in and which refers to the ordinance as the substantive act. And I think what has happened is since that Amendment Act, in general usage, the ordinance has been referred to as the Act.
Very well, thank you.
And so your Lordship does have the right piece of legislation, but just so your Lordship has the complete materials, could I ask to be handed up a copy of the Amendment Act so your Lordship can see how it's been addressed? I think there are 5.
I see there seems to be some confusion in the court. And I see page 1860, for example, it's talked about as an act which is operative in every state comprising the jurisdiction of the Eastern Caribbean State Supreme Court, which may be styled so as to identify the particular territory, but its substantive provisions are the same. That's one version. Another version says it was renamed the East Caribbean Supreme Court Virgin Islands Act, but doesn't say by what statute it was. And Wikipedia doesn't help.
Well, I'm sorry that's the case, my Lord. My instructions are simply that since this Amendment Act of 1993, which I think has just been handed up, which refers to the ordinance as the substantive act, I think as a defined term, the usage has been that the ordinance is now the act, or at least that's in common parlance within those practising the British Virgin Islands anyway, if that's any assistance. My Lord Wilson also raised a question with my learned friend as to the judge at first instance indicating that the confidentiality club provisions would not be lightly varied, and if I may respectfully say so, your Lordship's entirely right in your recollection, and indeed I did raise with him the possibility of it being expanded to encompass those lawyers representing my clients who had not yet been called to the British Virgin Islands, but who were members of the English bar and who were solicitors in this jurisdiction, but his Lordship was not willing to extend it even to them. And for your Lordship's reference, it's in the record, MS page numbers 202 and 204, where I think you will find references to those things. My Lord, just to turn then to the substantive points raised by my learned friend, and I hope I can be quite quick. What seems to be the essence of my learned friend's submission as to what actually constitutes an injunction within the relevant legislation, is whether or not it would fit within the description of an injunction granted by way of equitable remedy as used in the judgment in the Magnani case, which Your Lordship was taken to, which I think is in Volume 1 of the Authorities at tab 11, where Mr. Justice Cumming-Bruce, as he then was, distinguished the relevant order that he was concerned with, which he considered to be sui generis, from an injunction coming within, I think, a predecessor of Section 37 of the Senior Courts Act, because an order made under Section 37 would be granted on the basis of equitable principles as a matter of discretion. If that is the correct defining feature which my learned friend is relying upon, then in my submission, that feature is satisfied in respect of an asset disclosure order in the same way as any other order that's made under Section 37 in England or Section 24 in the British Virgin Islands. And Your Lordship can see that if we need to go to authority for it from the McLean-Watson case, where Your Lordship has that, I think, in the first volume of Authorities at tab 10, and it's in particular at MS page 1682 at letter D, where Mr. Justice Millett in the court below had said, it's a passage I actually took you to earlier, that the source of the jurisdiction for the disclosure order was the same as that for the freezing injunction. And so was the ground, for exercising it, namely that it appears to the court just and convenient to do so. And that is a rubric for the application of equitable principles as they pre-existed prior to the Act coming into being, and which Mr. Justice Cumming-Bruce was referring to in his case. So if we need to use that as the touchstone, then it is certainly satisfied. The only other matters I just wanted to refer to is the suggestion that any other form of order could be made the subject of a committal process simply by putting a penal notice on it. And there's nothing special about injunctions and having such notices and having committal available as a procedure for enforcement. I respectfully submit that's not correct. If one was to do that in relation to any normal procedural order, if I can describe it that way, for delivery of witness statements, for service of pleadings, or indeed for general standard discovery, it would in fact be an abuse of process to do that. And the reason it would be is the passage explained in the passage in Professor Zuckerman's text that I took your lordships to and ladyship to earlier, which is in volume 5 of the Authorities at tab 87, MS page 3166. And in particular, the passages at paragraph 11.215 and 11.216 and 11.217, where he makes the point that orders for a party to perform particular procedural steps within a certain time scale, such as serving a defence or a witness statement, doesn't alter the electable nature of the procedural duty. Notwithstanding an order of this kind, the party continues to be free to elect to suffer the procedural consequence rather than comply with the order. And where procedural requirements are electable in the sense just explained, the court has no jurisdiction to commit a litigant who fails to comply with such requirements for contempt of court. And it matters not whether the process requirement is imposed by a rule, practice, direction, or court order. And then he referred to the observations of Lord Denning in support of the proposition, that whenever there's a reasonable alternative available instead of committal to prison, that alternative must be taken. And that is based on the Danchevsky case, which he cites there. And the appropriate response in those cases is to apply the consequences specified by the rules or court orders for failure to comply, And that might be an unless order to strike out if you don't comply, or for you're to be debarred from defending if you were a defendant.
In fact, I wondered whether Professor Zuckerman identified the relevant principle at 11.222 on page 3168.
Yes.
Where he says contempt proceedings are also available where a party's conduct goes beyond mere failure to fulfil process requirement and amounts to subversion of the administration of justice. And then he gives examples of that.
Yes. Yes, there of course are the instances of making a false statement of truth and so on, but in those cases, certainly in a false statement of truth case, you normally need to apply to the court first for permission to bring a committal application, and then one can be brought. But certainly there is
anyway,
that.
It crossed my mind whether that would be the principled explanation for the practice that my lord and my lady described in the family division, where you need to get information from a husband, for example, about his assets in order for the court to do justice thereafter between the parties.
Yes, my lord, with respect, it seems to me that's an explanation. I'm afraid I wasn't myself familiar with the procedure either.
Well,
perhaps not so familiar with the family division, but like your lordship, my only experience of penal notices and contempt proceedings is really in the context principally of breaches of injunctions, although I have seen them being brought in the context of a false statement of truth, but normally you have to first apply for permission to bring committal proceedings first, and it's a rather exceptional category. But normal, what I'll call regular procedural orders, which you might find being made at a case management conference in the course of the proceedings, would be enforced by other mechanisms, as the Professor has indicated. Your Lordship, I think, was taken to the CPR of the BVI. I respectfully submit they don't take matters very much further and don't affect the statutory basis for grant of permission to appeal or to allow appeal to be made without leave, which is what we're concerned with here. And then finally, my learned friend really tries to get to what is the nub of his contention, which is that he says that the freezing injunction directly protects the party who applies for that order, whereas the disclosure order only indirectly does it, because it's only if it works in conjunction with the injunction that you get the protection. And he therefore wants to submit that it's therefore not of a protective nature, and this is what distinguishes it from an injunction. With respect, they've got absolutely the same purpose. They're both seeking to protect the party from a defendant disposing of his assets or concealing them in order to defeat the ends of justice. It's just that they work in conjunction with each other, and one is very much dependent on the other in practical terms. And it's a false distinction to try to suggest that the disclosure order is not directed at that objective. It is. Lord, final point is the suggestion that all the cases, ones that we've been looking at, are, in particular the early authorities like Beckel, were ones in which the court considered that leave to permission to appeal was required, when the English rules were similar to the BVI ones. My Lord Wilson has already made observations about that, which we submit are correct, that the court often gives permission, de bene esse anyway, just in case you might need it. But actually it goes further than that, because in Beckel and Bilton, the learned judge at first instance had actually granted the order based on, as he thought, the jurisdiction in the rules of the Supreme Court. He thought the basis for the jurisdiction was not Section 37 or its equivalent, but something in the court rules. And if it was the court rules rather than the injunction power, then you would need permission to appeal, and that's why he granted it. The Court of Appeal concluded that he was incorrect, and that the power arose from Section 37, not the court rules. And therefore, on that basis, permission would not have been necessary. Well, unless I can assist you further, those are our submissions in...
Thank you very much. Well, we're most grateful to both counsel for their assistance. We'll have to consider the submissions and tender advice to Her Majesty. We're mindful of the anxiety of the appellants that they obtain a decision sooner rather than later. So we will do what we can to expedite the process.
I'm most grateful.